Welcome to the first and only episode of Right Opinions Radio. In reaction to proceedings in the Washington State Supreme Court, today we're going to explore the complex topic of judges' right to seize firearms from individuals in civil trials. I'm Abby.
And I'm Mia.
Si-
To begin, let's briefly review the difference between a criminal and a civil trial. In a criminal trial, a defendant is being charged for a crime by the state. The state may be prompted to arrest based on a petitioner, but the prosecution is always the state. If found guilty, the defendant can be sentenced to such punishments as imprisonment or fine. To convict, the prosecution must prove the defendant's guilt beyond a reasonable doubt.
In a civil trial, nobody is being charged with a crime. A petitioner files a lawsuit against a respondent to whom they feel they should be compensated for some wrongdoing from. Most commonly, these cases are related to personal debts. If the court decides the petitioner is in the right, the respondent may be ordered to pay the petitioner in some amount of money or other assets, but they will never be sentenced to criminal charges in a civil trial. Rather than proving guilt beyond a reasonable doubt, civil trials are based on the lesser preponderance of the evidence, basically meaning that the petitioner is more probably in the right than in the wrong.
Because of the fundamental differences in these types of cases, proceedings are significantly different in the treatment of the participants. When defendants in a criminal trial have often been arrested and I completely lost my spot. Thank you. And are kept in prison throughout and leading up to the trial. In a civil trial, all parties are generally free but still legally obligated to arrive at court. So while seizure of dangerous items like firearms are commonplace and uncontested in criminal trials, it's much more of a gray area in civil trials.
To understand the specific situations we're looking at today, we should first understand the broader concept of civil asset forfeiture, instances in which the state can seize from individuals that have not been convicted or are on trial in a criminal case or any legal case at all sometimes.
The existence of civil asset forfeiture is the United States has always been in the United States has always been controversial, especially in recent years, as it is often seen as existing in conflict with the Fourth Amendment, as often the justification for seizure from citizens is based only upon suspicion. The practice began essentially to make it easier for law enforcement to combat the illegal drug trade. Suspected drug traffickers could have their financial gains seized without the evidence of drugs to make it difficult to profit from the trade, and the proceeds go directly to the funds of the law enforcement agency.
But this essentially means that any property can be easily seized without trial, and worse, law enforcement is actually incentivized to do so. Cars, land, money, anything. It's very difficult to receive anything seized in this manner back. The San Francisco Chronicle estimated that less than 1% of federally civilly seized assets are ever returned. There are several reasons for this. Because the items are seized without trial, it's actually the citizen that must file a case to recover their property instead of the state filing a case against the citizen to take it. But the most difficult aspect is that in these cases, the uh, to contest the seizure, these trials are in rem or power against the thing jurisdiction, which means the trials are actually against the item itself instead of the individual. Almost all trials, in the way you think of them, are in personam or power against a person, but these cases are against the item, which sounds absurd, and it is. In rem cases have names such as Nebraska v. 1970 two-door sedan Rambler Gremlin, and United States v. 450 ancient cuneiform tablets.
In rem, jurisdiction originates mostly in either cases where property is identified but the owner unknown, or in admiralty law regarding vessels and related debts. The process of these cases is confusing due to their unorthodox nature, but essentially the guilt of the object is the subject of the case. Take the aforementioned Nebraska v. 1970 two-door sedan Rambler Gremlin case. Donald Rule was arrested for possession of marijuana while that he was transporting with the car in question, but the car was seized as civil asset forfeiture, not as part of Rule's sentencing. And when Rule contested the seizure, he had to prove the vehicle's innocence rather than the state proving its guilt, as objects do not have the same civil rights as people do. It's no wonder why critics often civil asset forfeiture as legalized theft by the state.
This often exists at the state level as well as federal. In Washington, particularly, RCW, or Revised Code of Washington, 10.105.010 outlines asset seizure and forfeiture. Its provisions hold that if a police officer has probable cause to believe an item was intended to be used for a crime, it may be seized, even without charging the person or obtaining a warrant. And any seized property will be considered forfeited if the seizure isn't contested within 45 days.
But why does this matter? Well, civil asset forfeiture may not be the same as seizure from individuals involved in civil trials, but it does provide groundwork for seizure of property of the non-convicted in the U.S., which makes understanding of the state's ability to seize from citizens with little cause important.
In Washington, several laws relate to the seizure of firearms in legal proceedings. The main law regarding firearm seizure is RCW 9.41.098, which states that law enforcement can seize firearms that are owned or have been sold illegally or in possession of arrestees or others awaiting trial for any felony or non-felonies that involve firearms. RCW 9.41.047 states that those declared mentally incompetent do not have the same rights to firearm possession of the general public. But all of these laws require legal action to seize, such as a court declaration of mental incompetency or an arrest.
There's also a process for voluntarily revoking your rights to firearms under RCW 9.41.350. When we come back, we'll touch on notes from Representative Mary Foss, Senator June Robinson, and more around the state.
This is true.
If she ever answers my email, it will be.
Welcome back. In the past few weeks, we've connected with a few representatives, senators, and judges around Washington state to hear their feelings. Mary Foss was the first that we contacted. She is a state-level senator for the district in which Everett is part of, and we contacted her particularly because she is on the Community Safety Committee, which we thought would be most related to seizure of firearms.
Were we right? I don't know. You can decide. She's a big advocate for strong gun legislation. Thank you. She's a gun owner and she supports gun buyback, but she believes that the protection orders aren't strong enough. She really believes in responsible ownership, and that we shouldn't have to take guns away from people. It's just that we need to, focus on the people that are having them. So like if there's someone who doesn't have mental health support and wants a gun, then that's probably a bad thing and we shouldn't do that. She really thinks that the country is lacking in mental health support and has an absurd suicide rate.
We also brought up an interesting case that we briefly mentioned in the intro to this, which is Washington v. Flannery, and that's the case where, and it's a case that we initially believed was about firearm seizure in civil trials. It's a little bit different. In Washington v. Flannery, I believe his name is Daniel Flannery, there's a protection order against him that immediately made it a felony for him to own firearms. And then the local government gave him a firearm seizure order saying if you have any firearms, you have to turn them in. But in order to turn them in, because there's no clause for immunity in that law, then he has to say, oh, I was owning these things that are a felony to own, even if he bought them legally. So because the law immediately made it a felony to own something that he was then ordered to give back, he argued that that was self-incrimination, which is a very specific scenario, but I just thought it would be worth mentioning because it's related to this topic, and it is what got us interested in this in the first place.
It's also currently pending in the Washington Supreme Court. It's gone through the Court of Appeals 3 times, something like that.
It got appealed a couple times, and I think the most recent one from the packet we were reading said that the court actually did uphold Flannery's claim. They said the government does need to grant him some kind of immunity with that firearm seizure order to turn his firearms because, like he was arguing in the case, otherwise he has to admit to a felony in order to do the thing he is now required to do, even if you bought them legally.
Yeah. Interesting stuff.
We will also question, but what is your dad?
A Snohomish County Court Commissioner.
We will also question a local court commissioner who brought the case to our attention.
Yeah.
And possibly explore various Washington state judges' opinions of cases like this and gun legislation in the state as a whole.